It's been 6 years since a cell phone, popcorn, and a pistol permanently changed the lives of a small family in suburban Tampa, Florida. Chad Oulson loved spending time with his wife, Nicole, and their 22-month-old baby girl, Alexis. Friends and family say Oulson was a genuine, funny, go-getter type of guy. On January 13th, 2014, Chad and Nicole Oulson were sitting in a theater waiting for a movie to start. And as the previews were rolling, Chad was on his phone, texting their babysitter to check on baby Alexis. This security video shows the man sitting behind them, Curtis Reeves, objecting to Chad using his phone, and the two start arguing. Then Reeves went to complain to the management. Here's Nicole Oulson recalling Reeves' demeanor that night.
I see you've put your phone away now that I went to get management. I remember feeling this should have been over. He's got what he wanted. Why is he still doing the, ha, you did what I told you, I won? That's kind of how it felt to me.
Witnesses told police that the argument continued when Reeves returned to his seat. In a recorded audio police interview, Nicole describes what happened next.
My husband said, dude, what's your problem? You know, I wasn't making any noise. The movie hasn't even started, and that's all I remember.
Then the argument went from loud to lethal. Reeves, a retired Tampa police captain, claims he feared for his life after Nicole's husband threw a bag of popcorn at him. In his police interview, Reeves said Oulson stood up and hit him in the face with an unknown object. Let's watch that again, slowed down. You can see what looks like Oulson's arm make a very quick motion toward Reeves. Here's how Reeves remembers the incident.
Get out of my face. I'm leaning all the way back in my chair as far as I can to get away from him, and suddenly he's virtually on top of me. And I think I'm saying either no, 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 or whoa, whoa, whoa. Suddenly my head was to the right, so he hit me with something.
And that's when Reeves pulled his pistol from his pocket and fired one shot at Oulson.
I did not see him pull it out, and I did not see him shoot it. I just saw the spark and heard the noise.
43-year-old Chad Oulson was taken to the hospital where he later died. Curtis Reeves was charged with second-degree murder. He says he shot in self-defense. At a hearing in 2017, Reeves' attorney tried to prove that this was a stand-your-ground case. The controversial Florida law allows people to use deadly force when they fear death or personal bodily harm.
A 6'4" individual standing, trying to come over that chair is terrifying.
But the judge ruled that the stand-your-ground defense does not apply in this case.
If I had it to do over again, it would never have happened.
Now, Curtis Reeves is set to go on trial for second-degree murder.
2014, and now here we are in 2020, and we still haven't had a trial. Let's bring in great criminal defense attorney, Jay Hebert, down in Tampa, Florida. Jay, great to see you. Has the defense already won this case by getting it delayed so many years, by fully litigating every issue as far as they can take it?
You know, it's interesting. In your last segment, you spoke specifically about the issue of time and how time is the enemy to the prosecution and time is an ally for the defense. In this particular situation, two specific things have occurred. One, the stand your ground law went up on appeal and a significant change took place, which kind of sent this particular case into kind of a standstill until that was resolved. And the second issue is obviously the issue our entire world is facing with the COVID virus. Mr. Reeves is now 77 years old, and he's been out of custody for 6 long years.
Yeah, I think that's a huge win. You know, you're talking about a retired police officer here. When you looked at that video, do you think that video will determine this case? You know, will the jury look at that and make up their minds about what happened here?
Well, certainly every time we have video evidence, it helps the jury to sit in those shoes and evaluate what was going on. As in any case, when a firearm is pulled, we have to look at whether it was justified, whether there was a right for the shooter to fear for his own life. The question the jury will have to answer is, did he get hit with deadly force? Was there enough force there to cause you to take, as we have talked about many times, meeting force with deadly force has to be the solution that a jury has to come up with. And this video, I think, will be a very strong indicator of where this jury will go.
It was popcorn, okay? So the other part of this is I love jury views. I love when the jury returns to the scene. I have no idea if that theater is still here, if it's in the same shape that it was. But I think that's an important part of this case, for this jury to understand they're in different rows and how large the seats were and whether or not there was an actual threat here. How important do you think that is? And is there any chance this many years later down in Florida that a judge would want or allow the jury to return to the scene?
I can tell you, and I know that we have covered trials and you have commented on trials that I've been in, that jury views are very important. I think they're critical for both sides. I was just at this movie theater this weekend, driving by there on my way back from Ocala. This is north of Tampa, up in Wesley Chapel. The movie theater is still there, but unfortunately, again, because of COVID, we know that these theaters are in real trouble. There was nothing going on. There was a lot of construction out front. My understanding is there may be some renovations going on, but I certainly would expect that both sides would want a juror to go out there and touch it and feel it and see it in the dark, because the dark is a big issue. And all of these things can be put into play by a jury view. And I agree with you. They're a great tool.
All right, now, but let's talk about, Florida. Now it's a self-defense case, right? He lost the stand your ground hearing. He lost the immunity hearing. So now he's got to go to trial. He'll be claiming self-defense. They're in different rows. It's popcorn versus a gun. Do you think there's a reasonable argument to make that he was in fear of great bodily harm to himself when he reached over from one, because he's in one aisle and they're not sitting next to each other. They're in separate aisles. So he's got to reach over with the popcorn. If we watch the video again, you can see the arm come through, but you don't even see his body of the victim.
And when we play the role of prosecutor that you have done over the years, and the role of defense attorney I've done over years, we both take our different positions. And in this particular situation, it's not only Mr. Reeves is going, his legal team, who are very seasoned, very veteran lawyers, are going to take a position that it wasn't only defense of himself, but defense of his wife, who was seated there too. As you saw in the courtroom clip, he's going to talk about, Mr. Escobar is going to talk about how big this man was and how intimidating he was, and the verbiage and the language. But at the end of the day, the real issue again comes down to the popcorn or the cell phone. Was that a deadly weapon? And as a result of that, are you in fear under a reasonable man statute, under a reasonable man position, that deadly force was going to be used against you? And the only choice you had was to fire that weapon to defend yourself and your wife. And that's where the chips are going to fall in this case.
Yeah, as I look at the video, I see the arm. I can't quite tell if there's contact made between the popcorn box and Reeves or the arm or hand of the victim, Chad Oulson. But as I watch that, is that an important fact, or is it just the perception of Reeves? Or is it the reality of whether or not he actually gets hit in the head with anything other than a popcorn?
Well, there was some issue involving damage to his eyeglasses, which means there may have been some form of contact made by Mr. Oulson prior to the shooting. So all of these issues, depending on which side of the aisle you're on, will be spotlighted. But again, I tend to agree with the evidence. The best evidence in this case will be that video, and the fact that Mr. Oulson was not armed, did not have a weapon, used popcorn and or a cell phone. Whether that's going to be enough to justify the use of deadly force in this situation, 6 people will make that decision in Florida, hopefully in April, if we're not delayed further because of the COVID virus.
All right. Folks, I tried to get a verdict out of Jay Hebert, but he's just not going there tonight. He's not going there tonight, but he's doing great analysis. Jay, great to see you. Thanks so much.
Always, Vinny.